the first to know Nsem-Pii TV.
Ejebu, eja, enya ababidu. Sanya yede kwame bafo Abronye ekoko piemu ewoko. The last time Nsem-Pii yede update no ebremo court no eka se yemfane nko na yemfane nko she Sh0cks Friday na yede no ababi piemu ewo yebe kaya yewura Godfred Jebu Adame eba be kasa edefa ho eka se ekwan awon ede kwame bafo Abronye fa so no enya ade se etwayi na ode tudwa se ono ankasa be pomoden na watimi ababi piemu ewo de Accra Circuit Court na ono ankasa abehwe na bibia etimi atotoye ene kwame bafo Abronye ababi piemu ewo court na abusuafo nipa ababe ku court wono enya asem kotwa Godfred Jebu Adame de osie eyoyo wababe du Freddy Blay ene NPP menka ne se NPP amanyoko ni nyina de ne won ewa Accra Circuit Court Abronye ankofie dia ene ho beye de pa na de yenko videos ni bi.
The law is here. The law. The law is here. The law is here. The law is here.
The police invited him on Monday, the 8th of September. He responded to the invitation by the police, went with his lawyers, submitted himself to interrogations. Within an hour of interrogations, he was whisked into NIB custody. The question is, why would the police investigating a matter and has its own police cells decide to send a citizen who is being investigated on a matter which is a misdemeanor into NIB custody? It must be stated that our checks at the NIB confirms that the NIB is not interrogating Abronye, neither are they investigating him. According to the NIB, they are only recipients of the man Abronye. In other words, the police sent him there that they should keep him. That is why they received him. But they are not the ones who are investigating. So the question is, why would Ghana Police Service claim to be investigating a person and rather decide to send him to NIB cells? Is it to punish him or what? Then they kept him the whole of Monday night, and Tuesday morning, being the 9th, he was brought to court. When they brought him to court, the police insisted that they still needed him for further investigation. Therefore, they want him to be remanded into lawful custody. Of course, the judge upheld the application and remanded Abronye to be brought to court today. And the sad part of it is that
he's being charged with two things mainly. The first is publication of false news with intent to cause fear and panic, contrary to sections 208 and sections 123 of the Electronic Transaction Act. And then the second offense is offensive conduct conducive to breaches of peace, contrary to section 207 of the Criminal and Other Offences Act. And so basically, for this statement, that is publication of false news with intent to cause fear and panic, he alleges that the accused person, that is Abronye DC, stated that the IGP, that is Yohonu, had met with NDC operatives in Akwetia in the turn-up to the elections, the Akwetia by-elections, which obviously would be the argument of the state in this instance that may have created fear and panic. And secondly, on this, the particulars of the second offense is that he, on his show, made certain offensive statements against the IGP.
Abronye is 29 years old.
He's not 29 years old. In fact, there were some inconsistencies here. It provided that he was 29, and then here it said he was 37.
Okay.
But those are
all right.
Errors that
that matters. Okay.
They may deal with. And that he made certain statements that IGP Tete Yohono collected bribe.
From whom?
From members of the... he says he made the statements that he is the most corrupt IGP in Ghana's history. And so as to the specifications of whom he collected the bribe for and for what specific purpose, we do not know. But he says he's a bribe taker and he is corrupt in nature. And so per the police charge sheet, they are claiming that these are statements that are not conducive, or that are conducive to the breach of the peace. To which these are statements that carry or have the propensity of causing a breach or a breakdown in peace and security, which is quite interesting. And so at the last court sitting, when they went to court the last time, the lawyers for Abronye made an application for bail. In fact, he appeared because he had been apprehended and kept for 48 hours. In Ghana, the law is that if you are caught for any offense, you must be kept for 48 hours maximum before you are brought before a court of competent jurisdiction for the court to give you bail. And so if an individual is arrested anywhere, the police has no right to keep him for more than 48 hours before he is brought before a court of competent jurisdiction. And this is the combined effect of Article 14 and Article 19 of the Constitution. And so that is what they adhered to. The courts, the circuit courts, denied the bail application of counsel for Abronye and remanded him to appear, that is tomorrow. In fact, the police made a claim or made the case that they need more time to investigate the charges they have proffered against Abronye, which is quite interesting because these are charges that hinge on an act. So if you see a video of me insulting the president and say that the president is whatever, and you charge me for offensive conduct conducive to a breach of the peace, all you need is the video. You have seen me in the video, you have kept me, you have asked me questions. I do not know which other investigations the police intends to conduct into this matter, but that was the case that was made before court, and so they told the courts that they want to keep, or Abronye has to be kept in custody to tomorrow. And so this is the offense in Act 29, Section 207. It says that a person who in a public place or at a public meeting uses threatening, abusive, or insulting words or behavior, and this is where it's very interesting, with intent to provoke a breach of the peace, or by which a breach of the peace is likely to be occasioned, commits a misdemeanor. Now, in Ghana's rank of offenses, we have a first-degree felony, we have a second-degree felony, and we have a misdemeanor. Misdemeanor is what would say an offense that is the least serious of offenses we have. And so the maximum per Act 30 for keeping somebody upon conviction is 3 years. That is, unless another law specifically mandates that even though an offense is a misdemeanor, the person can be kept for more years. And then this is Section 208. It says a person who publishes or reproduces a statement, rumor, or report which is likely to cause fear and alarm to the public or to disturb the public peace, knowing or having reason to believe that the statement, rumor, or report is false, commits a misdemeanor. So this also is a misdemeanor. I do not see how, but this is a value judgment, I do not see how saying that the IGP is corrupt may lead to a breakdown in security or public security. But I think these are opportunities to test the legal system and see
well, perhaps the point is people will lose confidence in the IGP and they will take the law into their own hands. Perhaps, I mean, if you want to stretch it.
Yeah, but that's the point, stretching. So in the US, they had occasion to decide a similar offense. And it was in the Supreme Court. In fact, the Justice Thurgood Marshall, who was the first black justice of the American Supreme Court, sat on that matter. And it was the case of Papa Christo versus Jacksonville.
Are you talking about Chief Justice John Marshall?
Thurgood Marshall. No,
Thurgood.
not John Marshall, the
I
old
saw
one.
1972,
No.
so I was
Thurgood,
very
the
confused.
first black.
Okay.
In fact, he
Clarence Thomas is not the first black.
No, Clarence Thomas is the second.
Oh, I
Thurgood
see,
Marshall
okay.
was the first. So Thurgood Marshall died, and Clarence was appointed to sort of replace, to keep that balance on the bench.
Okay, I see.
So in this case,
What's the name? What do you pronounce that
Papa
name?
Christo. It's Greek.
It sounds like Ghanaian, Papa Christo.
Okay.
Okay.
The city of Jacksonville.
Yeah. And what
So the
happened in
city of
case?
Jacksonville had enacted a law that banned what we call it had a vagrancy clause. So people who loiter, people who are found walking aimlessly, it made that a criminal offense.
In which state?
It was in the city of Jacksonville.
Jacksonville, okay.
Yeah. And so the matter went up to the Supreme Court. And
Federal
the Supreme
Supreme
Court. Federal. It was a bench of 7.
Okay.
Justice Rehnquist and another judge did not sit, but it was 7. 7-0 majority. The Supreme Court in the United States held that any law that gives law enforcement agencies the room and the wherewithal to convict as and when they wish is vague and consequently should be declared as unconstitutional. There was an attempt to apply this in Ghana in the case of Sh0cks versus the Attorney General, where Sh0cks sought to pray before the Supreme Court that the offense of willfully causing financial loss to the state is unconstitutional because it's vague, willful, and all that. But the Supreme Court held that we can interpret what willful is, we can interpret what causing loss is. And so in that instance, that attempt to
Causing
use
loss is a
vagueness-
mathematical outcome.
It's a mathematical outcome. And so you look at the fact that maybe procurement laws were not followed, and consequent to that, there was a loss occasion to the state. And so it is simple.
The contract was not done.
It wasn't done properly. It didn't go to parliament. There was no opportunity for it to be audited. You bypass your chief director of the ministry, all those things. And so the Supreme Court in this instance did not apply the vague test, the test of vagueness in Ghana. However, it does not mean that that argument is lost on us, because the general principle in criminal law is that criminal laws are supposed to be interpreted strict and firm. And so, for instance, it's similar to the Bible. When God gave Moses about over 600 laws, the rationale behind God giving Moses and the Israelites those laws was to ensure that things were very, very specific. So, for instance, there was not a lot of room for Aaron and the prophets to do a lot of interpretation in those things. So God will say, if you wear a garment where 2 fabrics are mixed, you must be stoned. If a male wears a female attire, you must be stoned to death. That's the nature of criminal law. And so it raises a jurisprudential discussion as to whether a law that says that law enforcement agents can say that any act which is likely to cause fear and alarm to the public or disturb the public peace knowing or having reason to believe that the statement rumor report is false. We should have the debate that does it give law enforcement agents a lot of room?
The discretion is in the word likely.
Likely.
But the report which is likely, that's where the discretion is.
Yes, the discretion.
Because then they make the determination whether this report is likely.
Yes.
The likelihood, using the word likely to apply to an offense,
it's a problem. Because an offense
is a problem. The word likely cannot be applied to an offense. Offense is specific.
Yeah. So, for instance, if you look at this definition of murder in section 46 of Act 29, it says that a person who causes harm unlawfully to another person and that harm causes the death of that person commits murder. It's a simple and straightforward. But in this instance, by you giving law enforcement agencies the room to make that determination may be a problem. So I think that it is true. Publication of false news must be, or publication of false news that indeed has the potential to...
It's a concern,
It's a concern. It's a public concern. I think what the law making body, that's the legislature, should do is have a more expansive definition of what publication of false news is. And more specific. So what publication is, the various media that publication may be done, the specific statements that qualify, and maybe putting something else that is false. And when we even say likely, what is it? So for a very good example is Rwanda. After the genocide, they were specific on issues. So if you go to the Rwanda, their laws are specific. They'll tell you that issues relating to tribe,
you cannot talk
about it. So here we now have to have a discussion. Is it inciting?
And even which people qualify to be prosecuted? Because if I stand here and say Minister XY has done this.
Yeah.
It carries more weight than a young man playing, do you know what totals is? The ball, for playing totals at circle and says that, oh, this minister has done that.
Yeah, the circumstances.
Yes, the way you approach my saying it should be completely different from you approach a young man who is saying it. Or some young man running to a political rally, shaking his flag and saying something about other people.
Exactly.
It's very different from a journalist who sits on the media and says this, or even if he puts on his Facebook page because of his following. All of that must be defined in the law. Yeah, the delimitation of who can do what is very important.
And so someone may raise the argument that, oh, but in any case, it is the courts or a court of competent jurisdiction that will make
that will determine the likely.
The likely. But the thing is, before the courts would even make the decision, most likely you would have been arrested. You would have been put through all that stress. You would have had to incur costs to get legal counsel. You would have been going up and down. Your bail may be denied. You understand? So all those things also factor.
So what's before the courts tomorrow?
Tomorrow he's remanded to appear before court, and most likely his lawyers would make a repeat application for bail. However, the state, the prosecution, still argues that they need more time for the purpose of investigations. No witness statement has been filed, disclosures have not been made, and so we wait to see.
So where is he being kept?
For that, I would suspect it's the CID headquarters, because I noticed that the former Attorney General, Honorable Godfrey Dame, was there today. In fact, there was a video of him being ushered to one of the buildings. But even before, I watched the video of the lawyer representing him, one lawyer, I think Daniel, at a firm in Accra, whose name I may not have permission to mention. So, and mentioned that even before they got the location of where he was, it was a bit of a problem. And all.
So it's not clear where they are keeping him.
But it says he's now had access to him, but initially was what I'm talking about.
Okay.
Initially. And so most likely you'd appear in court, the circuit court, tomorrow. And then these matters.
Circuit court what?
Circuit court 9. It's at Accra Central.
To his appearance in court tomorrow, is there any hopes that he will get a bail?
Yes, he's in high spirits, very good condition. Even though, of course, I advise him to try and eat some food. Yes, but he's still in very good spirit, and he's looking forward to continue to the proceedings tomorrow. And we're very confident that bail should be granted. I think in a matter like this, clearly a misdemeanor, all offences under section 207 and 208 of Act 29 are misdemeanors. So really, there's little justification as to why a trial court would even deny bail. We have seen it when people are actually attacked in elections, gravely assaulting other Ghanaian citizens and all. They are granted bail and they are put before court. And when they plead guilty, even before the court will deliver a sentence, the court itself grants bail, and they come out with some slight fines. I mean, so clearly you see that all these processes amount to what I call a deliberate discriminatory application of the law. And it's this uneven application of the law which must be deplored. We cannot live in a country where some citizens of the country are treated in a worse form than others.
When listening to what transpired in court the last time, the argument I heard was advanced for the denial of bail is the fact that he has initiated move seeking asylum, and so when he's granted bail, he could leave and then the process will stop. Don't you think that warrants the granting of bail?
That is spurious, very, very spurious. I mean, asylum seeking is according to law, is it not? And I do not think that there has been a conclusion of any such processes by the gentleman. And so the question is whether indeed it's really an offense for a person to seek asylum, and whether it's also an offense for the person to make a comment that another person considers unsavory or unpalatable to that person. I think all this is really putting the country in such a very poor light. And as I'm saying, that is the lowest we can get to as a democracy. It should not happen at all. And we should not condone it. All these excuses are very spurious and unfounded. Kind of strike, hunger strike or not, but he says, yes, he's not trying to eat. His wife is in there, and when his wife comes out, he can explain. I've advised wife to employ all kinds of means that she knows best to ensure that the husband eats.
Following your visits, have you gotten the assurance that his lawyers will now have access to him?
Yes, so the lawyer had to essentially, for one better expression, seek cover under this visit. The lawyer came in whilst I was there, and because I was there, he's been granted access to him to engage in some kind of conference with the client. But the most important thing is that tomorrow the matter is coming up, and I'm sure the court should be minded to grant bail. Yes, I mean, even the most serious offenses that I prosecuted in my time, treason, the treason trial, on the very first day, all the accused persons were granted bail. And so when I say that this is in stark contrast to a situation which just preceded this administration, I mean, I speak so on solid facts. I mean, I prosecuted very high-profile figures in the NDC, Colin Dauda, Atufosin, and now Rich Japa, who has been given such a high office in this administration and all that. All of them were granted bail, very, very flexible terms. Atufosin, self-recognized has been. Colin Dauda, the same thing. Even Japa, when he had difficulties and all that. And just the Supreme Court called me. I don't know at all. Let him be allowed to go and come and continue your process later on.